Under California law, it is illegal to harass or discriminate against a pregnant female. Unfortunately, as we've seen these economic times be difficult, and we've seen companies begin layoffs, we've seen all too often that those are affecting pregnant women disproportionate to the rest of the workforce. Because under California law, a pregnant woman has the right to take up to 4 months of leave for the birth of her child. Before delivery, the law requires that if that pregnant female requires some form of an accommodation, the ability to sit, the transfer to a less strenuous position, removal from a position that might have exposure to harmful chemicals, then the employer is supposed to accommodate that pregnant woman if they can do so without a form of an undue hardship. And what is the employer's requirement upon the end of the pregnancy leave? The employer must return the employee to the same or similar position that they had before that leave began. What we all too often see is that an employer hires somebody as a temp during the time that a pregnant woman is off caring for her newborn. And then, when it's time for her to come back to work, the employer says the job has been eliminated. But the person who was hired as a temp stays on doing the same tasks that were done by the woman who took off leave for pregnancy. Because many employers have a perception that a woman with a newborn is going to be distracted and will eventually become a stay-at-home mom. So what the employer does based upon these prejudices and these preconceptions is violates the law. So if you've been harassed, that is treated differently or made fun of because you were pregnant, or you've had one of these rights of yours violated, contact us. We are very familiar with how to handle these cases, and at the time that you should be having joy with your newborn, you should not have to worry about the safety and security of your family or your job.